So I think we can start. So esteemed colleagues of the FACTI Panel, ladies and gentlemen, let me thank all of you for joining online at this consultation held in a very difficult situation. On behalf of the panel, I wish you, your families and your friends and colleagues continued health and safety. I would also wish to thank the Secretariat, who is doing a very consistent, professional and efficient work. I'd like to thank them for organizing this event despite the challenges that we are facing. This panel, as you know, is a joint initiative officially launched on 2nd of March 2020 by the Presidents of the General Assembly and the Economic and Social Council, with a view to enhancing the financing for the Sustainable Development Goals. We are an independent panel accountable to the President of the General Assembly and the President of the Economic and Social Council. So mobilizing sufficient resources, and particularly domestic resources, for implementing the 2030 Agenda for Sustainable Development is, as you all know, a major challenge. And there is no doubt that this challenge will be exacerbated by the current economic downturn and financial turmoil due to the COVID-19 pandemic. However, we are fully convinced that the only way forward is to remain committed to global cooperation between governments and among governments, the private sector, and civil society in support of sustainable development. In fact, the work of this panel is especially important now, as many countries are facing drastic economic slowdowns and associated decreases in public revenue. More than ever, the proceeds of corruptions that are being laundered across the planet represent much needed funds for developing countries. Indeed, due to scarce public health resources, weak revenue generation, heavy debt obligations, and declining official development assistance, developing countries are also likely to pay the highest price from COVID-19. In the case of Africa, for example, the Economic Commission for Africa estimates that we are losing in the African continent $65 billion a year. The recovery of proceeds of both corporate and grand corporation is of critical importance to enable developing countries to address the consequences of a pandemic and to help them weather future shocks while supporting progress on the Sustainable Development Goals. Ladies and gentlemen, this is the panel's 5th virtual consultation and the 3rd one with experts. This consultation addresses the panel's cluster of work on cooperation and settling disputes. Let me briefly update you on highlights of the panel's work since the launch. Despite restrictions on international travel and meetings, the panel has already begun its substantive work. On 31st of March, the full panel held its first video conference with all members attending. The panel has reviewed the background paper prepared by the Secretariat, which is available on the panel's website. The paper provides an overview of existing international frameworks related to financial integrity, analysis of cross-cutting issues, and recommendations of topics for possible future consideration by the panel. On that occasion, on 31st of March, the panel agreed to split up further to split up further work into 3 clusters. Cluster 1 is about improving cooperation in tax matters. Cluster 2 on accountability, public reporting, and anti-corruption measures. And Cluster 3 on cooperation and settling disputes. The cluster leads were also agreed. The panel has also started to engage with stakeholders. We met with member states on 24 April, with civil society organizations on 28 April, with anti-corruption experts on 30th April, and with tax experts 3 days ago. The panel will continue with an open and transparent approach to its work. And these 2 characteristics, openness and transparency, are directly linked to our independent dimension. Indeed, for the panel to make actionable recommendations, we need to engage regularly with all stakeholders. The panel is likely to complete its full interim report in September and its final report in February 2021. The panel has convened this experts consultation as we want to hear what your views are regarding priority actions for improving international cooperation in cross-border corruption and asset recovery cases. Secondly, intensifying foreign bribery investigations and prosecutions. 3, enhancing asset recovery and return. 4, strengthening peer review processes. And 5, fostering capacity in developing countries. The panel would also like to solicit ideas on which areas the panel can generate sufficient political support in light of the challenges the world is currently facing. Evidently, a strong political support will allow the recommendations to be actionable, and a weak political support will create resistances to the implementation of these recommendations. All your inputs will feed into the interim report of the panel, and I thank you in advance for your contributions. Please note that the meeting will be recorded and posted online in the next few days. So at this time, I would like to pass the floor to Irene Ovonji-Odida and Thomas Stelzer, FACTI Panel Cluster Coordinators, who will provide us with an overview of the approach of this cluster. So, Ms. Ovonji-Odida, would you like to go first?
Thank you very much, Chair, and good morning or good afternoon to everyone. In cluster 3, we'll be looking at a range of issues, and I'll talk to the first set of issues, and then Thomas will talk about the second. The issues that we will be considering in relation to cluster 1, which looks at tax matters, will be the scope of cooperation and dispute settlement that touches on matters to do with taxation, recognizing that dispute settlement can occur at different levels between states and non-state actors, and between non-state actors, for example, multinational enterprises and communities. Secondly, and this is both from the discussions we've had in the panel and also from emerging issues in the previous consultations, the issues around coherence in dispute settlement mechanisms for business disputes in relation to taxation and investment. And issues of coherence that have emerged relate to relevance of UN commitments from foundational principles and instruments in norm setting and in various forums. Issues that have been raised include things like inclusion, transparency, sustainability, states' extraterritorial human rights obligations, and so on. Coherence also relates to the question of the connection between business and human rights and other areas such as climate change and environmental impacts, gender and corruption. The coherence also relates to questions to do with enforcement and lack of robust compliance mechanisms. And we will also be looking at the role of various regional mechanisms and facilities, their effectiveness and their relevance to build upon. The third area for this relates to global governance, the gaps, the costs, the effects, and issues that have been raised include that dispute settlement systems are fragmented or underdeveloped, so we'll explore that. The marginalization of developing countries from global governance in international regulatory architecture. And what has been flagged is about the systematic exclusion of developing countries from norm setting, which is one view that has been raised in rulemaking on taxation and in standard setting on fiscal issues. Other issues that have emerged relate to options regarding solutions at national level or international level. And at a national level, what has been proposed by a number of speakers relate to a UN tax tribunal, which is proposed or considered as an impartial international body. The issues that have been raised in relation to national tax authorities and the national judicial processes and their role and strengthening their role in tax dispute related settlement. And some of the questions that have been flagged here relate to sovereignty and policy space and how international rules impact on that. In addition, looking at the role of national authorities, the question of cooperation and how to enhance cooperation between them, for example, in enforcement measures, but also the questions around funding, financing, which is partially related to capacity issues that may be experienced. And on the global governance, a final issue was around enhancing accountability of states and multinational enterprises, and the question of participation of citizens and civic organizations such as NGOs, trade unions, and media. Three final areas to do with this. There were concerns or issues that have been raised about investor-state dispute settlement mechanisms, ISDS, and these issues broadly fall into questions to do with the principles applicable to them, about access, transparency, issues around tax justice and tax sovereignty as they play out. A number of speakers have talked about secrecy in ISDS processes as a problem, and the issues around the power dynamics and political interference impacting on ISDS mechanisms. And so we would be analyzing gaps in the existing architecture relating to ISDS mechanisms, and have also been asked by speakers from some states to look at the asymmetry in the experience of states in adjudication before ISDS mechanisms under various investment treaties, and any links that these adjudication may have, or impact of corruption or human rights, or the relevance of those issues within adjudication. And the question of costs of international arbitration for dispute settlement has also been raised, as well as the mandatoriness of international arbitration. And finally, two last issues which relate to the international and national political economy and the impacts of those on dispute settlement. This was referenced by a judge in one of the last calls that we had around significant power networks, both at global and local levels, with influence and, as she put it, endless financial resources interfering in judicial processes, or as other speakers said, in norm setting at global and state levels. And linked to that, a number of speakers have raised the role of enablers within the system and the links of dispute settlement on related issues in taxation to the offshore system. So the role of banks, accountants, auditors, lawyers, and the need to engage these intermediaries regarding professional standards in order to strengthen the application of principles from the human rights system or UN system in dispute settlement. And finally, on the national and international political economy, the question of incentives for the private sector to support reform. So what sort of recommendations can incentivize private sector actors to support reforms? And lastly, on international cooperation, which connects to the points raised by the co-chair at the beginning, questions around resources and adequate or inadequate financing of dispute settlement mechanisms and the links to capacities, and the use of technology and the need to have mutually reinforcing domestic and international actions. And finally, the legal redistribution of settlements for social programs. Thank you.
Thank you very much, Ms. Wanji Wadida. Can I ask Thomas Stelzer to take over?
Thank you very much, Chair. Greetings from the International Anti-Corruption Academy in Vienna. Since Austria is easing restrictions, I could come out of my home office today and come to the Academy to participate in these consultations. Thank you, Irene, for your comprehensive introduction. I can be short, just adding a little bit. On the first issue, priority actions for improving cooperation and standardization on bribery investigation and prosecution. We will try to analyze ways to enhance the very much needed collaboration among UN member states on investigation and prosecution on bribery and corruption crimes, promote a more active sharing of the relevant best practices and lessons learned, and facilitate contacts and exchange of experiences among practitioners, investigators, prosecutors, and specialized anti-corruption units investigating and prosecuting bribery and corruption crimes. While examining options to strengthen the peer review process, this will help states to enhance their compliance with the anti-corruption standards and help international community to understand what the major problems with the implementation of the international anti-corruption instruments are, and devise cooperative responses and mechanisms to promote compliance. Then, on the third issue, exploring options to improve capacity and international cooperation on asset recovery and return. This is a fundamental principle of UNCAC. We will focus on major difficulties the UN member states experience in asset recovery, taking into account the importance of the recovery of proceeds of crime and corruption for sustainable development and stability, and identify actions that can be taken at the national, regional, and global levels to enhance the implementation of the relevant agreements. And finally, on the fourth issue, on ways and means to tackle the challenges the world is facing in relation to cooperation and settling disputes. International cooperation is key for the implementation of the regional and global anti-corruption commitments. We will be building on the work of the COSP Working Group on International Cooperation, explore possibilities for enhancing cooperation among existing bilateral, regional, and universal frameworks for international cooperation related to anti-corruption efforts, facilitate direct interaction, and analyze the reasons for the numerous reservations made. Of course, in general, we will try to identify recommendations that ultimately will contribute to a better implementation of the Sustainable Development Goals, efficient and effective anti-corruption policies at national, regional, and global levels, which are necessary to promote the inclusive and sustainable growth. Our approach, and that has been requested by some of the participants in previous rounds of consultations, we need to include all the stakeholders, civil society, private sector, academia, and of course, the intergovernmental processes. So we are looking forward to all the comments today by the experts to our cluster. Thank you very much for giving me the floor.
Okay, thank you very much, Irene and Thomas, for your contributions that will allow us to open the discussion. And before we proceed with the interventions, let me ask you all to mute your microphones to avoid background noise and to keep the interventions clear. If you would like to take the floor, please use the raise hand button in the Zoom app so that the Secretariat can keep track of your request. Also, in case you lose sound or video, try refreshing the browser window or try to log out and reconnect to the meeting via a link which was sent priorly by the Secretariat. Finally, I want to stress that this is meant as an interactive session amongst experts. So please keep interventions concise to allow time for the large number of participants to participate. And please do not read long pre-written statements or country positions. The panel has opened the call for written submissions. So we request that you make use of this to submit material in writing. Now we can get started. We have 5 initial interventions already set, and then we'll have a more open dialogue. So the first intervention will be made by Mrs. Emile van der Does de Villebois, coordinator of a Stolen Asset Recovery Initiative. So please, Mrs. van der Does de Villebois, you have the floor.
Actually, Dr. Mayaki, Mr. Villebois is having troubles connecting through the phone.
No, actually, I managed.
Are you? Okay, fantastic. So here we go. Sorry.
I'm sorry to have got the gender wrong, but
that happens a lot. It's the E at the end. Yeah.
Okay.
Don't worry.
Okay. So please. Okay.
Thank you very much.
It's Emile. It's Emile. No, it's not Emily. Yeah. Okay. Okay.
Exactly.
Sorry.
Thank you very much, co-chair, and good morning, afternoon, evening to all the panel members and other participants here present. Thank you very much for the invitation to the Stolen Asset Recovery Initiative to give you a short presentation on what our views are, particularly in regard, of course, of asset recovery and international cooperation. We basically, Stolen Asset Recovery Initiative, which is a joint World Bank UNODC initiative, exists to make Chapter 5, which Mr. Stelzer mentioned in his introduction on asset recovery of the UN Convention Against Corruption, to make that real, to give, to make sure that that materializes, that becomes successful. We do that via a number of different strands of work, one of which is our country work, which entails capacity building on financial investigations, knowing how to conduct money laundering investigations, how to set up an income and asset disclosure system, do legal drafting, but also involves making sure that countries who have been affected by corruption can reach out to the international financial center. So it involves us really playing a role of honest broker between requesting and requested jurisdictions. Then we have another strand of work, which is really more knowledge and policy work, where we draft and gather expert opinion on various topics that are relevant to the national asset recovery agenda, be it beneficial ownership, income and asset disclosure, politically exposed persons, a whole range of issues. And under that umbrella, we also have the Asset Recovery Watch, which is trying to gather the hard facts on asset recovery. How much is really being returned? And as numerous people have mentioned already in the introductions, what that shows is that so far the amounts recovered are really a fraction of the total amounts that are stolen through corruption each year, and that only really a few international centres are actively engaged in recovering and returning assets. And as an aside here, a quick plug for the Asset Recovery Watch. We're currently updating it and have, through the UN system, sent a request to all member states, all parties to the UN Convention Against Corruption to provide us more information, because it's very, very hard to get clarity on this. But even if we were to get such clarity, I'm pretty confident that the main conclusion will still be the same. It's only a few countries that are really doing much on this, and only very small amounts are being returned. And so the question arises, why is this? Why is it 15 years after the UNCAC entered into force and this, groundbreaking new chapter on asset recovery, why has it not progressed as successfully as we hope? Now, there are a whole host of reasons, but I've been asked to keep the intervention short, so I'll only focus on 2 or 3 just here, and I'm sure that others will highlight other points. One of the issues we find very frequently in countries that we work with who want to start recovering assets back from international financial centres is a lack of domestic cooperation, the lack of a lead agency in the country that is willing to, that is able to take the lead, and that can draw on information supplied by all the different constituents in a country system to provide that information. You see that most agencies want to sit on their own information and want to get information from others, but are very unwilling to share. And already in the introductory comments, there were some comments about tax as well. One of the things we see is that there is an overall non-inclusion of the tax authorities when it comes to international asset recovery. So there's a sort of silo between, on the one hand, legal law enforcement authorities, and on the other hand, tax authorities. And again, those problems of internal cooperation then affect the country's ability to cooperate internationally. In one country where I was recently talking to different agencies at different times, all those 3 agencies had requests outstanding to the same jurisdiction, even on the same case, without having informed each other of that. And that sort of illustrates how the lack of internal cooperation then affects international cooperation. The other is, another issue that frequently arises is a lack of clarity and willingness to cooperate and to engage by financial centres. For the requesting jurisdictions, those who have been affected by corruption, it's very hard to know whom to turn to and what requirements of the requested jurisdiction are. What are the procedures to engage in international cooperation? How do you find that? It's often shrouded in opaque legalese language, which is hard for those who are not familiar with those countries. So for those authorities that are not familiar with international cooperation, it's hard to know what's going on. And so it's important that the international financial centres provide total clarity on what their rules are and how you get this information. So a number of years ago, we worked in the context of our Arab Forum on Asset Recovery, and later then with the G20 Anti-Corruption Working Group, on elaborating asset recovery, country asset recovery guides, where countries set out, these are our rules on international, and not in sort of legal language that no one's understand, but in clear, terse language this is how we can talk to you. These are our channels, and including to this level of detail. This is the email address that we, or the telephone number, or the institute that you would want to be in touch with. And we have those general asset recovery guides, and we have also elaborated in that context more specific beneficial ownership guides. So beneficial ownership is an issue that comes up a lot. Investigators find a trust or an international business company with assets and then don't know how they get information on that. Well, we have also developed these beneficial ownership guides. So providing that clarity by the international financial centers through these guides, I think should be encouraged. There have been a number of countries that have done this, but this could be adopted more widely. And then finally, one point, and I realize I'm already running out of time here, but one point I'd like to mention, which isn't so much an impediment to a recovery, but I think could encourage more activity, is elaboration of a more detailed set of rules and principles to govern international asset recovery. Of course, the UNCAC, the UN Convention Against Corruption, is a very solid basis and very good, but as it is a treaty, it is of necessity of high level, and it needs to be complemented by more detailed guidelines and principles on how to recover assets. And here I'd like to draw attention to two sets of principles / guidelines: the Lausanne guidelines for the efficient recovery of stolen assets, which was adopted by the Asset Recovery Working Group under the UNCAC 6 years ago, I believe now, which really goes into detail of how the different countries that are requesting and requested jurisdictions should be collaborating with each other, and was developed under the auspices of the Swiss, with input from the International Center for Asset Recovery and ourselves. And then the other set of guidelines I want to mention are the GFAR, the Global Forum on Asset Recovery Principles for the Disposition and Transfer of Confiscated Stolen Asset in Corruption Cases. That's a whole mouthful, but these were principles that were adopted 3 years ago when we organized, hosted by the UK and the US here in Washington, and organized by the Stolen Asset Recovery Initiative, the Global Forum on Asset Recovery. And there are set of principles emphasizing such things as transparency and accountability, the importance of early dialogues, inclusion of non-government stakeholders in the process, that I think would help in ensuring further activity on this issue. There are, as I said, there are a whole lot of other issues that I'm sure next speakers will draw on. Importance of practitioner networks. Enablers is a massive topic that Mr. Bongiorno already mentioned. But I realize my time is up, so thank you very much, Chair, and hand it back to you. Thank you.
Thank you, Mr. de Villebois. I very rarely do that, but I will use my co-chair position to ask you a question before we open discussion. Amongst the 3 reasons that you mentioned, on the basis of a diagnosis of it's only a fraction of the stolen assets that are recovered, I have 2 questions. One is, which reason, which cause do you think is the most critical, if there could be one, or they are interlinked so we can't flag one particular critical cause? And the second one is, what is your opinion on the trends currently, which could allow us to be optimistic or pessimistic regarding the way we tackle these 3 reasons?
Thank you. It is very hard to separate the issue of lack of domestic coordination and cooperation, which generally goes to the relative, I mean, the convention has been enforced for 15 years, but it's still a relatively new topic, certainly for affected jurisdictions. You know, the whole principle of conducting financial investigations, all of those things, relatively new. So it is, in that sense, not very surprising that there is both a certain lack of coordination and knowing how to do this within the countries themselves, as it is maybe not that surprising that the financial centers have themselves done too little to go out into the world. So I'd be hesitant to say it's really this. I mean, if you want to sort of find a communal thing behind it, you could say, you know, that there is a certain lack of trust on both sides, where on the one hand, the International Financial Center says, oh, well, this is the country where the corruption happened. Why should we cooperate with them? And on the other hand, the requesting jurisdiction says, well, actually, given that these international financial centers were happy to take our money in the first place, why should we trust them when it comes to giving that money back? So there is that underlying trust issue, and it is very difficult to untangle. What trends should make us optimistic? Well, certainly in the last few years, and I think our update of the Asset Recovery Watch will show that, we have seen more substantial returns, and not only that, we have seen some quicker returns. I'm thinking in particularly in the case of, for instance, Malaysia, where very shortly after the government changed hands 2 years ago, you saw very positive cooperation between Malaysia and a number of international partners, and returns within the year, which might not seem very quick, but is actually quite remarkable. So I will say that, and of course my job depends on it, so I would say that, but I will say that I'm cautiously optimistic. Thank you.
Thank you very much. So now the second speaker is Ms. Henny Verbeek-Custers, Head of a Financial Intelligence Unit in the Netherlands and Interim Chair of the Egmont Group of Financial Intelligence Units. Ms. Verbeek-Custers, you have the floor.
Thank you very much, Mr. Chair, for giving me this opportunity. And I know the question is to be concise, and that's exactly what I will try to do. But allow me to elaborate a bit on the three components, the three organizations that are important. The financial intelligence units that I'm talking about, the units in every jurisdiction, more or less uniquely positioned between the private and the public sector. They're the organization that receives, analyzes and disseminates suspicious transactions, and amongst them those transactions that have to do with the laundering of the proceeds of corruption. The Egmont Group, it's an operational international organization comprised of 164 FIUs, and it is facilitating the international exchange of information between FIUs as well as the sharing of expertise. And then it's the ECOFEL. It's the Egmont Center of FIU's Excellence and Leadership, which is a capacity building structure within the Egmont Group, and which allows us to, in a much more advanced way, share expertise, share knowledge, and support FIUs that are in trouble. As mentioned, what is important to understand is that this structure was created based on the anti-corruption program of the Cameron administration in the UK, because of the interpretation of the role FIUs could and should play in the fight against corruption. It was deemed to be important to allow the Egmont Group to have a better capacity building structure. If we look at the topic at hand, what we have identified for FIUs in this unique position to be better positioned to play their role in the fight against corruption and retrieve the stolen assets is that this FIU is supposed to be operationally independent and autonomous, in order for not to be influenced by politics, by PEPs, to be able to do its job. This is also based on international standards as developed by the Financial Action Task Force. What we have done in the Egmont Group is that we have elaborated on what does it mean for an FIU to be operationally independent and autonomous. And in ECOFEL, a self-assessment tool has been developed and a training course has been developed in an e-learning manner, which has now been used by 900 participants. And what is very important in the light of what we are discussing here is the FIU tools and practices for investigating laundering of proceeds of corruption. It's a mouthful, but it was the result of a project where we have identified tools, methods, techniques, and indicators associated with the laundering of the proceeds of corruption. It is both for FIUs to understand in what way to analyze, what to look for, but also what is very important, we have developed a set of 72 indicators which have been provided to the private sector to enable them to better detect in their data, in their transactions, what might be red flags or indicators of proceeds of corruption, for them to be able to share that, to report this to the FIU. And what is also a very important part of the project, also going back to what Emile was just elaborating on, it's the cooperation between FIUs and other domestic competent authorities, such as the National Police, such as prosecutor offices, public-private partnerships. And by that we have developed an FIU toolkit in order to support FIUs in a more effective fight against corruption. And then last is a report that has been developed. It's a bit of an older report that is focusing explicitly on FIUs working with law enforcement agencies and prosecutors. Again, because we also have experienced that only when cooperating in a more effective and efficient way with other authorities, we can become more effective. And what we believe is of importance, speaking from the Egmont Group, is that we have to enhance the exchange of information. So far, our information exchange is based on bilateral exchanges of information. And we have seen, looking back at also grand corruption cases that are of a complexity that is not always served by only bilateral exchanges, that we want to develop towards a more, what we call joint or multilateral exchanges of information, where FIUs in the jurisdictions that are involved in the schemes can cooperate from the beginning to understand better the information that is sometimes hidden in the data. And that is the second thing. What we are looking at now in the Egmont Group is to enhance the IT that we need in the international domain for this advanced exchange of information. Well, again, there's a lot to say. What's also important, I think, is another project that's underway, and that is looking on how FIUs can better cooperate in identifying the proceeds of serious tax crimes, but I will leave it here. Thank you.
Could I ask you a question? In a scale of 0 to 5, how well are you satisfied about the quality of the exchange of information?
Between FIUs, I would say 3. We can do more and we can do better. Yeah.
Okay. Thank you. Thank you very much. Now, I would like to turn to the Honorable Mark Wolf, a senior United States District Judge and Chair of Integrity Initiatives International. Please, Mr. Wolf, you have the floor.
Thank you, Mr. Chairman. As you said, I am a senior United States District Judge. I'm in Boston, Massachusetts, but I'm speaking to you in my capacity as Chair of Integrity Initiatives International. III, as we call it, was founded in 2016 by Justice Richard Goldstone of South Africa, the first chief prosecutor for the International Criminal Tribunal for the former Yugoslavia and Rwanda. Other colleagues and myself, we very much welcome the FACTI panel and are impressed by how hard you're working, because the origins of the FACTI panel are very closely connected with the origins of III, as we call it, and its missions. We founded III because we perceived that there was a critical gap in the international framework to combat corruption, and that that had devastating consequences for human rights, for human health and welfare. And that gap is the fact that the UN Convention Against Corruption, the UNCAC, is not effectively implemented, especially in countries ruled by corrupt leaders, commonly called kleptocrats, as you know. Kleptocrats who rob their citizens of funds that are urgently needed to meet the Sustainable Development Goals, among other things. And they do that with impunity because those corrupt leaders control the police, the prosecutors, and the courts. And they won't permit the prosecution and punishment of their families, their friends, themselves, and those who enable them. So we urge the FACTI panel to give priority to finding ways to strengthen the enforcement of criminal laws to combat corruption generally, but against high officials particularly. Transparency International has made a statement to the UN General Assembly special session on corruption scheduled for next year that discusses a range of means to strengthen the enforcement of criminal laws to combat corruption. III supports all of them. They're succinctly summarized in an article by Gillian Dell of Transparency International. But Transparency International singled out the proposed International Anti-Corruption Court, for which III is a leading advocate, as one means that especially deserves exploration. And I'd like to use the remainder of my time to introduce you to this idea of the International Anti-Corruption Court. The fundamental premise is that corruption is not flourishing in many countries because of a lack of laws. 187 countries, as you know, are parties to the UN Convention Against Corruption. They all have, or almost all have, laws that make extortion and bribery, money laundering, and misappropriation of national resources a crime. And they have obligations, I would say, under the UNCAC, but certainly under other treaties, to enforce those laws, including against their highest leaders. But as I said earlier, in many countries, including countries from which some of you come, those laws are not enforced, particularly against high-level officials, because those officials control the police, the prosecutors, and the courts. UNCAC monitoring evidently was designed to be weak, and it is. As I understand it, officials doing the monitoring have no absolute right to even visit the country involved, and the country being examined controls what, if any, information from UNCAC reports is made public. In 2013, Transparency issued a report, which I think made an observation that remains valid, that the international community seems to have focused too much on seeing whether countries have the laws and institutions required by UNCAC and insufficiently on whether those laws are actually enforced. I think it's important to recognize that transnational corruption can't be prosecuted pursuant to the, well, officials cannot be prosecuted pursuant to laws like the Federal Foreign Corrupt Practices Act, the FCPA in the United States, and its OECD convention counterparts. Under the FCPA and its counterparts, only individuals and organizations that pay bribes can be prosecuted. The public officials who demand those bribes cannot. And the failure to have anything that addresses the demand side of high-level corruption is a very important flaw in the international system. There are many American and other multinational corporations that are honest and would like to invest, they would like to work in developing countries, but they can't because of the extortionate demands for bribes. They're honest, they don't want to pay bribes, and in the United States and several other countries, they face the credible threat that they'll be prosecuted if they do. So this is the reason that an international anti-corruption court is necessary to prosecute corrupt leaders, kleptocrats, and those who collaborate and enable their crimes. I can only touch on this very simply now, and we will make a written submission, but the proposed International Anti-Corruption Court in its current conception, which is not a finished product, would be similar to, but separate from, the existing International Criminal Court. It would be stronger than the International Criminal Court. It has certain inherent advantages. For example, as you well know, kleptocrats do not tend to keep their illicit funds in their own country. They launder them through often several other countries. If any of those countries join the International Anti-Corruption Court, those kleptocrats might be prosecuted in the IACC. The International Anti-Corruption Court would operate on the principle of complementarity, the way the International Criminal Court does. If a country was unwilling or unable to prosecute its highest officials itself, they would be vulnerable to prosecution in the International Anti-Corruption Court. But if a country did have the will and the capacity to deal with it themselves, the International Anti-Corruption Court would not exercise jurisdiction. In the International Anti-Corruption Court, as we envision it, would become a resource, the way CICIG was a resource for Guatemala for many years, to strengthen the capacity of national governments that do want to do better, but have a history of entrenched corruption and are not capable of doing it themselves. Vast sums, of course, are lost to corruption, including grand corruption. It's almost impossible to deal with it adequately after the fact. It's essential to deter this corruption, and the credible threat of prosecution will do that. Angola, I think, provides a vivid illustration. The president of Angola for many years, Jose Eduardo dos Santos, I believe, was president for 38 years until several years ago. He made his daughter Isabel the head of the state oil company, among other things, and the richest woman in Africa at a time when half the people in Angola had no access to medical care whatsoever. And one of the last things that President dos Santos did as he was leaving office is give immunity to his family from criminal prosecution. Corruption is a crime of calculation, and it's important to change the calculation. The threat of going to prison will change the calculation. Has a lot of potential to. Another thing that's the International Anti-Corruption Court would do, and I don't think this is adequately understood very widely, it would be a very needed and effective means, promising means certainly, of recovering and repatriating illicit assets. When I impose a sentence in a criminal corruption or fraud case, I tend to sentence the defendant to prison and order that they pay restitution. And perhaps more significantly, for the purpose of this discussion, the UK has become increasingly energetic in doing this. In the 4 years before 2018, the UK reports that it recovered and repatriated 49 million pounds, including millions that went to Chad for projects for the poorest people there, and funds that went to Kenya to buy ambulances. Finally, you're interested in political feasibility, and the main argument that we hear against the International Anti-Corruption Court is that it is impossible. This will have opponents. The countries that opposed or complained about the creation of the FACTI Panel will not, I expect, support the International Anti-Corruption Court, at least initially. But it is politically feasible. This is a growing campaign that's being led by the Global South. In 2016, as he was earning the Nobel Peace Prize, Juan Manuel Santos in Colombia made Colombia the first country to endorse the International Anti-Corruption Court. Several weeks ago, the current administration in Colombia made a strong statement to the FACTI Panel calling for the creation of this court to end impunity, to enforce the UNCAC. In 2018, President Buhari of Nigeria, speaking at the anniversary of the International Criminal Court, called on the world to create another international court emulating the ICC that would serve as a vehicle for repatriating the assets of, that have been stolen through corruption. The IACC has growing support. Jeffrey Sachs, one of the engines and leaders of the Sustainable Development Goals, has been giving us invaluable advice and assistance. Major NGOs, Global Witness, The Sentry, Human Rights Watch, support the International Anti-Corruption Court. And very significantly, courageous young people around the world whose indignation at grand corruption is toppling kleptocrats in many countries are enthusiastic supporters of the International Anti-Corruption Court. Last June, at the international experts meeting sponsored by the UNODC in Oslo, 140 experts in the closing declaration called specifically on the world to explore the creation of an international anti-corruption court as a needed innovation to end impunity, something that should be explored to be on the agenda of the UN General Assembly special session on corruption next April. And my colleagues and I very much hope that the FACTI panel will do the same. Thank you very much.
Thank you very much, Mr. Wolf, and thank you for this plaidoyer for the International Anti-Corruption Court. You referred to a fact that UNCAC was designed to be weak. Am I right?
That is what I said.
Okay. Can you elaborate just 1 minute on that?
Yes. I testified on this to the implementation review group several years ago. It appears to me, and I don't have as much expertise as some people on this panel, that the UNCAC was a compromise. And there's a monitoring mechanism, but the monitoring mechanism does not give UNCAC monitors the right or didn't about 2 years ago, to even visit the country being monitored. And the country controls what information is public. It was only a summary, not the whole report when I focused on this. And there are other mechanisms. Greco in Europe, I think, which monitors the EU, has a much more robust, or did, monitoring mechanism. As I said, I think you have people who could tell you the history of the UNCAC even better, but my understanding, and I also taught about this at the Harvard Kennedy School, is that there was a compromise to get the UNCAC under the leadership of Kofi Annan, and I think many countries signed the convention, in candor, signed the convention because they didn't expect it was going to be enforced. It's something of a double-edged sword, in my view, right now. It does provide an important legal basis. However, it also lets countries with corrupt leaders hold themselves out as foes of corruption, because they say, well, we have all these laws, and we have all these institutions, and we're getting high marks from the UNCAC monitors, who are kind of checking the boxes that the laws exist, that the institutions exist. But as Transparency International wrote years ago, focusing excessively on what's on the books and not enough on implementation. And as I understand it, this is one of the critical questions for your FACTI panel. You know, how do we improve implementation, and how do we fill gaps? And that's why my colleagues, several of whom I know are on this Zoom, and I are so grateful for the creation of the panel over some formidable opposition, evidently, and for the very hard work that I can see you're doing. We appreciate it.
Yeah. Okay, thank you. Thank you very much, Mr. Wolf. So now I'll turn over to Ms. Abiola Makinwa. You have the floor, Ms. Abiola.
Thank you. Thank you for this opportunity to contribute to such an important topic. I'm going to take a slightly different tack from Mark and also from Donald, who is in the comments speaking about an international court. I think a key priority area for achieving the 2030 agenda that I would like to draw our attention to is the opportunity to address the fragmented, conflicted, underdeveloped, anti-corruption dispute settlement landscape that exists from if we can better implement Article 39 of the United Nations Convention Against Corruption. Now, I will reference Article 39 calls for cooperation between national authorities and the private sector entities. It also calls for cooperation between national authorities and individuals as an integral pillar of anti-corruption enforcement. I think this is an area where the UN process can stimulate the full implementation of Article 39. There are 4 key points I'd like to briefly put before this forum that arise from this notion. The first point is the importance to encourage states to develop cooperation-centered dispute settlement regimes as opposed to the focus on traditional criminal prosecution in the courts. For 2 reasons. First of all, obtaining the full cooperation from the private sector entity or individual as a precursor, as an integral aspect of the dispute resolution process can help us to finally overcome the profound challenge we face in traditional criminal prosecution of information asymmetry. This information asymmetry handicaps the best efforts of national authorities to detect, to prove acts of corruption that occur in secrecy occur in very complex, multi-layered, multi-jurisdictional transactions. So this has proven to be beyond the capability of many national authorities, even the most advanced countries. And this lack of capability fuels impunity, and we really need to find a way to address information asymmetry. Article 39 provides a roadmap on how we can overcome impunity in that regard. Secondly, this operation leverages the self-interest of private sector entities. On their part, it introduces new efficiencies, it lessens risk, reputational or otherwise, and it essentially creates a business case for compliance, which incentivizes private sector partnering in anti-corruption enforcement. So that's to the first point, encouraging the development of cooperation-centered dispute settlement regimes. The second point I'd like to make is that we need to now develop criteria by which to stimulate and reward, as well as assess socially valuable behavior by private sector entities. Specifically, when private sector entities take actions focus on preventing acts of corruption from occurring in the first place. For example, internal controls, putting in place robust anti-bribery agreement with third parties, with agents or other intermediaries, putting in place robust anti-bribery management systems and compliance programs, putting in place effective whistleblower systems. I think it's very important that we develop criteria by which such behavior can be stimulated and assessed and encouraged. The third action point, and I'm going to really be very quick now because I'm aware of the time, is the need to address the growing damages gap. In the anti-bribery enforcement field, settlements are becoming the primary mechanism of dispute resolution, and Article 39, properly implemented, should also address the questions of access to justice and compensation by the ultimate victims of corruption and include them in a structured way in this settlement process. And there are examples of countries that have already done this in their own local rules. For example, the UK and the Netherlands are examples that quickly spring to mind, where compensation to victims is an integral element in the factors that are considered in arriving at a settlement. My last point is that there is an urgent need to address the uncertainty that is resulting from a rather fragmented anti-bribery enforcement landscape. Countries are adopting settlement regimes, but they're adopting different forms and different approaches. So there is an urgent need to introduce a measure of harmonization or principles regarding this question of corporate liability in bribery cases. And I would like to refer to the 2018 Structured Settlements for Corruption Offenses report of the International Bar Association, the 2019 report of the OECD, and especially to the work of the Recommendation 6 network that has been led by Tina Sorieda and Peter Somson on this call, all of which support the call for common principles. Now, I think common principles require common action, and this is an area where the United Nations can provide leadership and direction. So those are my 4 points that I consider an urgent priority if we hope to achieve the 2030 agenda. Thank you.
Thank you very much, Ms. Makinwa. I forgot to mention that you are from the Hague University of Applied Sciences. So now the final intervention, I would like to turn to Stefan Karingisi, Director of the African Legal Support Facility. Mr. Karingisi, you have the floor.
Thank you, Your Excellency. Sorry, it took a bit of time to unmute it. to unmute. As you've indicated, Stephen Karangizi, the Director for the African Legal Support Facility. So maybe let me start with why the facility was established. The raison d'etat for establishing the facility was to support African countries in defending themselves in litigation involving what is colloquially called vulture funds. So third parties that purchase debt and then enforce the original debt agreement at extortionist prices. That has led us to increasingly support countries in international disputes. And what has also become our biggest support to the countries is in terms of providing them advisory services whenever they're negotiating major agreements, which is normally the starting point for the corruption for many of subsequent illicit flow of assets, because the agreements at the starting point, if they are weak, means that the pursuit of the rights for the states becomes difficult, and it's also easier to transgress them. I would say 3 points mainly on international dispute settlement. I think that some of the points have been highlighted by Irene. The first point is the institutions at national level and the appreciation of arbitration is lacking. Most of the arbitration arises from the so-called investment agreements, bilateral investment. They come in different forms, which are usually lopsided. Most of the agreements provide for settlement of those disputes outside the continent. Unfortunately, there is a huge asymmetry in terms of not only the participation of the countries in those dispute settlement arrangements, but also in terms of representation on the panels. You take, for instance, ICSID, 30% of the cases are from Africa, but only 2% of the arbitrators are from Africa. So, I mean, you have all those issues that complicate. And then, of course, above all, the cost. So I think one of the things we should be looking at is try and move a lot of that dispute settlement to the continent, encourage the establishment of national and regional dispute settlement arrangements. And then, of course, the capacity building, ensure that capacity is provided. We are trying to provide as much as we can, but it's like you're plugging holes in an umbrella that is old. The second thing relates to assets in terms of exiting the continent, the issues around the assets. I think the first issue relates to the description of those assets. Fortunately, at the moment, it's too strict, making it difficult for the countries to pursue what would be their assets, because proving that they've been stolen and they are illicit is quite difficult for them. I think the second thing also relates to the institutions. I appreciate the proposal to establish an international anti-corruption court and so on, but I think it's better, as they say, charity starts at home, to encourage the national institutions, have ways in which you can motivate them to enforce those agreements, if not national, at least region. I know that the African court already, the revised one, already makes provisions for some of those provisions he was mentioning. So I think if you can encourage national and regional institutions, then you create an understanding and appreciation of the need to pursue a lot of these cases at that level. I think then there's the additional point with respect to assets is the whole issue of the treatment of the assets once they are recovered. There's a lot of uneasiness. We managed to assist one country recover their assets. We mainly get requests after there is a change of government. During the time when there is a government in place, you don't normally get a request for recovery of these assets, because there's also the issue of how do you treat the assets once they're recovered. I think when we are looking at modifying the relevant provisions of ANCAC, there should be an emphasis on allowing the country that lost the assets to be the one that makes the decision on how the assets are managed, at least returned into the national coffers for priority areas. Finally, I think one cannot overemphasize that the whole issue of enforcement in the case of awards is also related to perception as to where the dispute resolution takes place. That's why I kept emphasizing that, try to encourage the resolution of those disputes at regional level, because if you maintain a perception that the countries have not had a role in the dispute settlement, enforcement becomes very difficult, and yet at the end of the day, you need to enforce the dispute awards at national level. I think I've tried to be quick because there's limited time. There's much more to cover, but I won't go into it because in the process of providing support to the countries, we also realize that in many cases, they are also challenged with changing dynamics in terms of what the private sector offers, more complicated arrangements, and also more complicated investment agreements of a different nature that come at a very high level. But that's a discussion for another time. Thank you, Mr. Chair.
Thank you very much, Mr. Stephen Karengizi. So we have come at the end of the interventions. You have all raised very good points. So now let me open the floor to FACTI panelists to respond. And Mr. Stelzer, would you like to go first? You need to unmute. You need to unmute. Yeah.
Sorry, I'm muted. I have no response at the time being. We'll discuss this with my co-panel members, and we take the interventions into consideration. Thank you very much.
Okay. No, thank you. Irene, would you like to respond or comment?
Thank you very much, Chair, and thank you very much to the scheduled speakers. There are just two requests that I'd make, that with the written input that you make to the panel, we would appreciate if you can also give evidence. So for example, evidence of effectiveness of the existing mechanisms in terms, for example, of funds recovered, assets returned, those sorts of things. Some of you spoke about existing indicators. What sort of picture do they give about the success of existing architecture? And just to mention that we will be doing, as I said earlier, we'll be mapping the various mechanisms and trying to build a picture of how effective they are. Secondly, that many of you have spoken as well to the question of fragmentation between the different mechanisms, whether it's at a global level or a national level in terms of cooperation. And so that is an important point that I've taken note of.
Thank you very much, colleagues, panelists. So I suggest that we now move to the open discussion. Please do keep your interventions brief so that we can allow the many interested participants to intervene, and so we can have an interactive dialogue, and the panel members can also intervene. But before we proceed, I would like to make a couple of suggestions for the smooth operation of this discussion. If you would like to take the floor, please indicate so using the raise hand button. Of course, please try to remember to unmute yourself when you are ready to speak. And please submit long statements by email and keep your interventions as brief as possible. So at this stage, I'm going to ask to Ms. Maud Perdriel of the Secretariat to call on the participants. Maud, you have the floor.
Yeah, thank you, Dr. Mayeki. So we've got 6 speakers. I mean, 3 who raised their hands through, who officially raised their hand, and 3 through the chat room. So I suggest that we proceed by group of 3. So the first 3 are Ms. Suad Aden Osman. Then we will have Mr. Rick Messick. And the third one is Peter Sol Sonsen. So Ms. Tina,
this is Juan.
Suad Aden Osman, sorry, you can go ahead.
Thank you, Od. I am Suad Aden Osman, the director of the Coalition for Dialogue on Africa. You cannot hear me? Can you hear me?
We can hear you. Yeah, we can hear you.
Now you can hear me, all right. Yes, I was saying I'm Suad Aden Osman, the director of the Coalition for Dialogue on Africa. We co-host together with the African Union Commission, the high-level panel on illicit financial flows. And I had 2 suggestions. One is as we are discussing the global governance, it has been highlighted in various platforms that the lack of a defined and holistic monitoring mechanism to follow on the multilateral cooperation commitments should be addressed if we are to really achieve any meaningful financial accountability and transparency. So my suggestion was that in 2001, the Economic Commission for Africa and OECD Secretariat had put in place something called the MRDE, an annual mutual review of development effectiveness. And it was annual and it carried on until 2013. And then for reasons that I'm not quite sure what it was abandoned. So maybe the FACTI process could help determine if there are lessons to be learned from that mechanism, or even look at as putting something similar in place. If it was found good at some point and the reasons were not the right ones, maybe it's time to look at those ones. And my second suggestion has to do with the FACTI panel, as it is going to engage all continents. In Africa, as you all know, there has been the AU high-level panel led by Thabo Mbeki, and we think that it should be considered as the entry point or the focal point, because the former President Mbeki and the Deputy Chairperson of the AU lead a group of African institutions that are currently organizing coherently what we call the African response to the scourge, and that consortium of African institutions is the most impactful platform in reaching out to all stakeholders, including African policymakers, particularly the African ministers of finance. Thank you very much.
Thank you very much. Thank you.
Yeah. So next on the list is Mr. Richard Messick. Please, Mr. Messick, you can go ahead.
Oh, thank you very much. It was a very rich discussion. I don't envy the panel sorting through the hundreds, if not thousands, of issues that arise in this complex world. I would urge them, when they do, to focus on realistic, attainable objectives that will make a difference. There's a lot of discussion we heard today about things that, well, for example, the International Court, that's been debated for a long time. The chances of it ever coming to pass, I think, are quite slim. One could look at the negotiating history of UNCAC, the recent experience with the International Criminal Court, and indeed the outstanding questions that have yet to be answered about the feasibility of the court in a lengthy discussion a couple of years ago on the global anti-corruption law. Compare that idea with one that arose during that discussion, perhaps appearing to be small reform, but one that's doable and make a significant difference. Require all countries, particularly countries where assets may be located, to disclose on a regular basis their backlog of mutual legal assistance requests. I do a lot of work with anti-corruption agencies in sub-Saharan Africa and in Southeast Asia. Their biggest complaint to me is they make requests for evidence to pursue cases to enforce, as Judge Wolf said, the criminal provisions flowing from UNCAC, and they get no response, or they get a response 3 years later after the statute of limitations is run, and they can do nothing with the case. The United States, 2 years ago, I think it was, admitted in a congressional hearing it had 4,000 requests from developing countries, mostly, that it had failed to answer within a reasonable time. Those are cases that the anti-corruption agencies can't follow up on. If we could urge the panel could use FACTI's authority to get countries to disclose on a regular basis how many requests they have pending, the average time they've been pending, and so forth. That would be a means for holding the governments accountable, both to their own civil society organizations and to the international community. So I wish you all the best. And again, I urge, focus your attention and efforts on what's realistic and attainable, because there's an enormous agenda here, and we want to make a difference. We don't want to just talk about it. Thank you.
Thank you very much. Okay.
Yeah. So next on my list is Mr. Solmsen. So please, Mr. Solmsen, you've got the floor.
Thank you. Thank you. This is Peter Solmsen on behalf of the International Bar Association. 2 quick points. At the risk of repeating what Thomas Seltzer reported and what Abiola covered, there is ongoing work by the 44 countries that make up the Working Group on Bribery on principles and processes to govern international settlements of bribery cases. There's a huge role for the UN to play in addressing the needs and perspectives of the countries that are not members of the OECD Working Group on Bribery. And that perspective, I think, has been to some degree missing in the ongoing conversation. So I urge you to look at what the Working Group on Bribery is doing, to support it, and to engage with it as that work goes forward. The International Bar Association will be acting to complement that work through its own projects, which will have commenced already. The second point I want to make is someone raised the question of gatekeepers, lawyers, bankers, real estate agents, all the people who get involved in transactions that support corrupt activities. The International Bar Association and the OECD have published guidelines which were extremely controversial, which I recommend this panel look at. Thanks very much.
Thank you very much.
Yeah, so now we've got the 3 last speakers from what I have. So first we have Ms. Tina Soreide. Then we will have Jeffrey Owens, and the last speaker would be Mr. Valerie Yao. So please, Ms. Tina Soreide, if you want to take the floor.
Thank you. Can you hear me? No. I I work on these set processes for better principles in corporate bribery cases and enforcement, and that has been a process, as Peter pointed out, that has been driven by the working group on bribery. But I think we all agree that corruption is a problem that has to be solved in the societies where the corruption plays out. And the UN is in a unique position to complement what the OECD working group does, as Peter pointed out, and Abiola. And I just wanted to point at three important manners. And because what we see in this work is that there is really a need to facilitate the cooperation between investigators. As Rick pointed out, this mutual legal assistance is really a huge problem, but there's no clear principle, and today it's very much up to the prosecutors in the countries that pursue cases against corporations to decide how that should go on. So it would be good if the UN could play a role in that. Also, secondly, it would be very good if the UN could come up as part of this initiative with a principle on how to share the fine revenues, because now many people think it is unfair the way these huge fine payments go to countries typically in the north, while the corruption is taking place elsewhere. And thirdly, also connected to the same sort of efforts, there should be some sort of vehicle, so the UN for returning stolen assets safely to the countries where the corruption has taken place. And several people has mentioned that, but I think the UN is in a much better position to do this than other actors. And with such initiatives, I think the investigations could be much more efficient, and of course that's essential for preventing the corruption to happen. Thank you.
Thank you very much.
Just to let you know, Dr. Mayaki, we've got two more speakers. So if that's fine with you, we might, after the two coming, there would be another two speakers, if it's okay. Okay, so now, so in total, we've got another four speakers, and I get that that could be the end of the open discussions because we're already running out of time. Okay, so the next speaker is Jeffrey Owens. So Mr. Owens, you've got the floor.
Thank you. I'm the director of the Global Tax Policy Center in Vienna. I have two comments and three suggestions, all relating to the question of cross-border disputes. The first comment is that it's a good time, in fact, to bring together the trade, the tax, and the investment community to examine what best practices you could derive from what they do in the area of disputes. Each of these communities is currently examining their dispute mechanisms, and I think there are good practices and there are bad practices that we can learn. For example, one thing that was just raised by one of the commentators was this question of peer reviews. I think you could look at the peer review mechanism that's been put in by the Forum on Tax Administration for the mutual agreement procedure, and that could actually be a model maybe for some of the legal reviews that were referred to, yes? The second comment, I think, is very much related to tax disputes. I think we need, there's a certain urgency here, because my expectation is we'll see a tsunami of disputes between OECD countries, disputes between OECD countries and non-OECD countries, and this is pretty recent, disputes between developing countries themselves. Yes? So we need to move quite quickly on this one. The three suggestions are, first, I think it would be good for the panel to ask itself, why is it that the developing countries have so little experience with the tax dispute mechanisms, the MAP, yes? Is it because of a lack of confidence in the processes? Is it because of a lack of confidence in the neutrality of the arbitrators? Is it due to costs? Or is it just due to a lack of capacity? Yes, I think asking those questions and getting an input from the developing countries would help take forward the panel's debate. The second suggestion is that on the basis of the answers that you get, you could look at what could you design a new institutional framework that would actually address some of the concerns of developing countries. And I think this is a real opportunity to actually go beyond what's on the table and ask ourselves, what more can we do? And the third suggestion, and I'll finish there, is to look at the work that's currently being done by the UN Tax Committee. They're preparing a handbook on disputes. Many of the issues, in fact, that I think you will be addressing have already been addressed by them, so I think you can draw on that. And then one last point, picking up a point that Emile made, I would very much agree with him that it's really important to get tax people engaged in the issue of the recovery of assets, something, frankly, that doesn't happen every day. Vienna will put in some written submissions on each of these points. Thank you very much.
Thank you very much. Thank you.
So now we've got Mr. Yao. Valerie Yao, yeah. From speaking on behalf of APRE.
So, as you are aware, established in 2003, the African Peer Review Mechanism, the organ of the African Union, currently voluntarily acceded by 40 African member states as a homegrown assessment for good governance or performance on the African continent with a unique methodology. I should specify that corruption and money laundering are practices that feature prominently in the 25 APRM country review reports. Following the release of the high-level panel's report on illicit financial flows in 2015, we support all the efforts of the CODA and other institutions of the AU in the development of the African position on the matter. As part of its role to improve good governance on the continent, APRM has already undertaken major steps and has integrated and domesticated the main issues raised by the high-level panel report in its questionnaire. The APRM supports that the national and international enforcement and compliance barriers to the implementation of the necessary initiatives to improve financial transparency and accountability must be looked at carefully by the FACTI to reduce the loss of much needed resources. You will recall that as the member of the African Governance Architecture, the APRM has led 2 years ago the first ever Africa Governance Report 2019, which was adopted by the AU Assembly. The APRM raises awareness and encourages African governments to address illicit financial flows in order to maximize their tax revenues, keep investable resources within the current countries, and impede criminal and corrupting activities at the continental level. The recommendation of the Mbeki report, which the consortium to stem IF from Africa develop a systematic and coherent implementation plan, should be given due consideration. And all and above, I think the process of the cooperation and asset recovery should be made transparent enough so that countries that are involved should know what are the expectations and what are the responsibilities. Thank you very much for giving the floor. I think we should make a written submission to you. Thank you very much.
Thank you very much.
So yeah, Dr. Mayaki, as I said, there were 2 more speakers. I also got some messages through emails, but as you mentioned it, people have the opportunity to send written contributions, and we are already running out of time. So I suggest we just take 1 speaker, because the other one, Mr. Donald Deya, proposed to submit precisely this written contribution letter. So let's just ask Shadid Kadar to take the floor, and then we could wrap up the meeting.
Perfect. Perfect.
Thank you.
Is that being, sorry, just a question for some of the panelists. Excuse me. We're talking about some of the issues that we are facing when it comes to recovery of assets. My question is basically twofold. One, bulk of the issues appear to be a stock issue. What do I mean by that? I mean, some of the problems relate to the past, when some of the data, some of the information perhaps is missing. For a variety of reasons, these are things of the past. The question is, has there been an improvement when it comes to the flow part? Is there reason for optimism that the procedures, the processes, the institutional structures, the frameworks have they improved? One of the questions that the chair itself asked. So my question is there reason for optimism? Because we are handling the flow part better than the stock. The stock is an issue which needs to be handled separately from the flow. And I would be more worried about the flow than the stock, because actually handling the stock will take much longer and is a much more painful process. Thank you.
Well, thank you, Mr. Kardar, for this question, which is at the same time a methodology comment that the panel can raise when it meets on Monday. Thank you very much. So at this point in time, I have the extreme pleasure to hand over to the co-chair.
Okay, thank you. Thank you very much, everybody, for very inspiring discussion. Every meeting we have more and more interesting consultations and more useful, I think, for our further work we will be able to do. And we hope that you will stick with us and with your engagement to help us to be efficient and resultative. But of course, some elements which we can highlight today with a wide range of your comments, I will say that we hear what you would like us to focus on national cooperation and information sharing among national agencies. This can apply to money laundering and financial crimes, asset recovery, corruption, prosecution, especially need to break the silo between tax enforcement and other financial crime enforcement. A focus on international information sharing, including suggestions for protocols, standards, and statistics reporting, especially on asset recovery and return. Also suggestion that we need to address impunity for those high-level public officials that demand bribes. Kleptocracy, we know what that means in some countries. Need to think about the role of private sector and how to incentivize compliance, and consideration of international standards for bribery settlement and the use distribution of fines with a potential stronger consideration of victims. So of course, I want also to add a little bit that I was looking to the chat a little bit, and I saw one proposal for us to expand a little bit definition of corruption. For example, that mainly we prosecute, or we try to prosecute everything what is illegal, but there are in some countries laws or actions in the framework of legal framework which are absolutely unethical. And the proposal from the chat I was reading, that we need to expand definition that is not only what is legally in this legal framework done, but also if it is unethical, we can call it corruption. And there are a lot of sorts of corruption, moral, no, I mean, in each country, of course, there is specificity, but, and also another thing which I heard very clearly, and for us, probably it's somewhere in our unconscious mind, from Rick Messick, that we need to face, and we are facing, small ambition, but to have realistic result, or large ambition, but probably not doable. So we'll see, after the long process of consultations, discussions, how much courage we have to go for larger ambition, maybe mix between what is doable and recommendations what needs to be done in future. So we'll see how we will manage, but with your support and enthusiasm and commitment, what I was hearing about trying to have ambitious goals, I think this is a good idea, and it is inspiring for all of us, because if you start thinking, if you start the job thinking that you will do only what you can do, you better not to start. And if you start and you think that probably you can do even more than you imagine you can do, I think this also will give us energy and some kind of sense of why we agreed to go to this panel and to do the job. So I am thankful very much for all your inspirational thoughts, proposals, and support, what we have been feeling during this all discussions. So, and I wish you all, of course, health for all you, your families, your loved ones, and the success in everything you do. And we hope to receive from you in written, in writing, the thoughts you have been proposing to us and not able to go to the open discussion because of time frame. And we hope that not only in writing, but in the process of all this forthcoming year, you will be with us and helping us all together to do the job, which probably is needed, and why we all are discussing here and talking together. So thank you everybody for these consultations for Friday evening, for some morning evening, and wish you again the best, and to your families also. Thank you very much.